Hi, Zachary C. Ashby from Ashby Law. Want to answer another question that comes up frequently, and that's whether or not attorneys can get text messages or request text messages. This comes down to what's called discovery. In discovery, we send out questions called interrogatories and a request for production of documents that the opposing party must answer under oath and must complete under oath, swearing that all the documents are complete, that everything's there. They must answer the interrogatories fully, to the best of their knowledge, and all of that can be used as evidence. And the reason we have discovery is so that that information can be exchanged, and really what the result is that we're able to reach agreements, and that should be done before you go to mediation, so both sides enter into a mediation or negotiations with equal amounts of information. It also allows you to prepare properly for trial, so that all issues, all facts can come before the court. And yes, text messages are part of that, can be part of that. And so we can request text messages from the opposing party. Now, when you do a request like that, you do have to limit the scope, because you don't want to ask for all the text messages the other person had for the last 2 years. So usually you'll want to do something like all the text messages about a subject, but probably even better, text messages with certain individuals would be good. So you can get text messages between your spouse and maybe a babysitter, or a coworker, or their parents, or even between your spouse and the children, something along those lines. And usually you can then use those text messages as evidence about what they'll say. And really the most common thing that we see is that the communication between the parties becomes an issue, whether or not they had an agreement, whether they discussed certain things, whether they were using abusive language in the text messages. Those sorts of things are usually part of the issue, and so we're able to show then exactly what the conversation was and where it went. Now, not all text messages, communication is can be a tricky art. Text messages can be misunderstood. Arguments can erupt because one person read a text message the wrong way, and really that is an important role that an attorney can play, is read those things a little more objectively and help you decide whether it will help your argument or even hurt your argument. Other uses of text messages can be showing that, well, maybe there's a conversation about hiding property, or exchanging cash, or something along those lines, or treatment of the kids, something that would be relevant to your action, to your divorce case. So that again, what you want to be able to do is approach mediation with a full understanding of the facts, the relevant facts that a court would use to decide your case. But also, because at least our philosophy is, if you're ready for trial, you're ready for mediation. So we do some very basic trial preparation ahead of mediation, so that we're ready to go, and so that we can reach the best types of agreements. Anyway, I hope that helped and answered some questions. If you have any comments or more questions, go ahead and comment below. Also, please like our Facebook page and find us on YouTube as well. If you have any other questions or like to talk further, you can always call us at 509-866-4111. Thank you.